take of Erin O'Hara from Vanderbilt and Gary Ribstein from Illinois. And with that, I'll...
Yes, thank you. Well, so many people have said thank you for organizing this conference. I include myself into this group. I think it's really a brilliant idea to have an exchange of ideas between American and European conflict lawyers. We had that 30 years ago. I remember that I wrote my first seminar paper as a student in Hamburg University with Herbert Bernstein, who later became professor here in Duke University, about the American conflicts revolution. And that it was a very common thing in those days. And then for 20 or 30 years, the links were cut off. And now, thanks to you, they have been re-established. Well, my paper is about federalization of choice of law. This point has already been addressed by Richard Fentiman, the integration purpose, and by Ralph Michels. My paper deals with the possibilities in a federal system to establish common choice of law rules for interstate conflict of laws at the federal level. Thus, it does not deal with international conflicts arising between a federal entity and third states. It does not deal with the content of those choice of law rules. It does not deal with efforts made at the level of the single states to cope with interstate conflicts that can only be second best. And it does not deal with issues of jurisdiction and recognition of judgments. The basic assumption underlying my paper is that the ordering of choice of law for interstate conflicts in federal systems is a task of the federal entity. Thus, my paper is focusing on the federal government's and the federal courts' role as a kind of referee in conflicts arising between single jurisdictions that are part of a system governed by shared values and a common constitutional text and precepts. It is, of course, a little bit dangerous to compare the United States to the European Union for various reasons, which are outlined in my paper. But I come to the conclusion that a cautious comparison is perhaps possible. The single states in the European Union have a much larger autonomy than the single states in the United States of America. They are subjects of international law, which North Carolina is not, and so on. So we have many differences, but still I believe that there is this common characteristic. We have a kind of constitutional framework which is common to us on both sides of the Atlantic. You have your constitution, we have our founding treaties. These treaties contain certain values which are basic to society, and on the basis of these texts, all legal systems, including choice of law, have to operate. The second part of my paper keeps track with what I call the gradual withdrawal of federal institutions from interstate conflict of laws in the United States. This withdrawal has had three elements. First, the Erie-Claxon doctrine, that there is no federal common conflict of laws rules except for areas of federal jurisdiction like admiralty. Second element, the abstention of federal legislation. You have, of course, this DOMA, but that's not very much. In my paper, I explain why I believe that politicians have no incentives to deal with this matter. because they would be constrained to act as a kind of referee, whereas they undoubtedly have to be loyal to their own constituency, which is always established in one particular state. So politics in this area is probably at the federal level not very promising. The third element that remained after the Claxon doctrine, the Claxon judgment, was the constitutional review of choice of law rules adopted by single states. But this third possibility of federal conflict of laws was watered down by the Supreme Court in Allstate Insurance and Hague. The significant contacts as required by the Supreme Court for the application of the choice of law rules of a single state exist almost always with several jurisdictions. Thus, courts sitting in different states may apply different conflict rules and, as a consequence, different substantive laws to one and the same case. Uniformity of solutions becomes fortuitous. The central objective of choice of law rules, that is, legal security in a multi-jurisdictional environment, is no longer pursued. And I insist on this objective, despite what Richard had said in his contribution. I think the addressee of choice of law rules cannot be only the judge. The addressees are all of us dealing with transnational problems in our private lives. The addressees of choice of law in tort law, for example, are also insurers who have to know in advance which will be the law applicable to a certain delict. Now, this objective can be attained by private actors only in those areas of the law where agreements on the applicable law are admitted and for practical reasons possible. At the level of the single states, courts have reacted to this withdrawal of federal regulation by adopting very different choice of law theories. I think if there had not been this withdrawal of federal institutions from interstate conflict of laws, probably the American conflicts revolution would have been less successful. Maybe it would have also been successful. But the federal courts, the Supreme Court, would finally have decided in favor of one of these various theories, or would have adopted a mixture of them. But since there was no federal decision-making in this area, 50 jurisdictions picked out from the menu of legal scholarship what they like best. The resulting situation is sometimes praised as flexible, but usually criticized as chaotic. It is hardly possible to predict which law will be applied by a state court to a transborder case. The starting point has, of course, been similar in Europe. Each member state has had its own choice of law rules, sometimes in statute, sometimes in judge-made law. Since 1893, nations, and in particular the European nations, have tried to create uniform choice of law rules in the framework of the Hague Conference, but only very few choice of law conventions have been ratified by a significant number of states. Thus, divergent national conflict rules applied by national courts of member states may lead to very painful results for individuals and corporations. What is needed is a kind of referee evaluating the different claims for the enforcement of their own laws, of the national laws. The existence of such a potential referee is something rather new in federal entities. If we take a look around, we will find that there are choice of law rules at the federal level to a certain extent, but very limited in Spain, in the former Yugoslavia, and the former Soviet Union, but they were all very vague and did not really give much guidance. And I think in this respect it is appropriate to talk about a European conflicts revolution. We now get, for the first time, rather hard and fast rules at the federal level. Choice of law rules have traditionally been framed by the single jurisdictions which try to enforce their own substantive laws and policies. Thus, choice of law rules have been used as a kind of delimitation of the own legal system as against other jurisdictions. What Federal Congress could do, and what the EC in part has already done, in the struggle between their members, is to act as a referee. Thus, choice of law in the European Union has a completely different function. It is no longer delimitation as against others, but it is part of the internal law of the European Union. The third part of my paper summarizes the case law of the European Court of Justice flowing from the painful situations that arise from conflicts between national laws of member states. I do not deal with judgments of the ECJ that interpret choice of law rules laid down in EC legislation. They exist as well. Rather, this third part focuses on the aforementioned disturbances. They result in particular where undertakings may not use in other member states advertising strategies or other forms of commercial communication which are lawful in their country of origin, because in other member states the courts will apply their own national law, which is more restrictive in this respect. There have been some cases in the Court of Justice about 1990 which deal with such situations. Then, as we have already heard, there has been a series of cases dealing with corporations. I shall not repeat that. And a third group of cases, which is now perhaps even more important, deals with the names of individuals. Perhaps it is interesting to report at least one case, Garcia Avello. That was a case of a Spanish father and a Belgian mother. They had two children born in Belgium. The Belgian authorities registered these children with the surname Garcia Avello. The mother had, however, the name Weber. The children were at the same time registered with the consular section of the Spanish embassy in Brussels, with a name which would correspond to Spanish law, Garcia Weber. Now, the father applied to the Belgian authorities to change the registration from Garcia Avello into Garcia Weber, but they refused. If you read the case report, you get the impression that the Belgian king personally decided on the case. But, well, the case was finally referred to the Court of Justice, and the Court of Justice said Article 18 of the EC Treaty, which guarantees free movement, irrespective of any economic purposes, to all European citizens, creates a right to have the same name wherever you turn up in the European community. The name must not be distorted by national laws. I think this is perhaps characteristic for this European case law, not only in family law, but also in corporations, also in respect of commercial advertising and so on. There are some substantive values which follow from the EC Treaty and which create a kind of second layer which has an impact on the conflict of laws. This, in the course of these decisions, the Court of Justice usually carries out a balancing process. A balancing process not between the laws of different member states and the policies pursued by Spain and Belgium, for example. You will not find anything on that point in the judgment. But it is a balancing between a community value, free movement, and a national restriction of that community value. And this is carried out on the basis of the proportionality principle. Certain restrictions are allowed, others are declared to be unproportionate and are rejected. Now, the question is, of course, could this process, this balancing process, be copied in the United States? Is there anything interesting in it? I have read some of the American cases, in particular the recent case Franchise Tax Board of California and Hyatt, decided by the Supreme Court. And there Justice O'Connor said, oh, we don't want to get involved into balancing the interests of different states. That has proven to be unsatisfactory. That's what was said. Now, I think perhaps this European way is something more attractive and something more manageable. If you balance the values of the community as a whole against certain restrictions which may be necessary or may not be necessary of the single state. And my question or my proposition would be to check within the American system whether this would be possible. It would not be possible on the basis of full faith and credit or due process, because they are dealing with interests traditionally between the various single states. But perhaps the privileges and immunity clause might provide such a platform for that balancing process. Now, I wanted to finish, or my paper finishes, by a report on what the European legislature has produced. You know all that. It has been discussed throughout the whole day, Rome I, Rome II, Rome III, and perhaps several other Romes which are in the pipeline. So I stop here and leave the floor to the next speaker. Thank you.
The current European revolution does not concern the content or the method of choice of law. It concerns the origin, force, and uniformity of conflicts rules. As we speak, as we all know, conflicts law is being taken over by the European Union, which enshrines it in legislation, and this legislation directly binds all member states and all courts, from Finland to Portugal and from Ireland to Greece. This is new. For over 3 centuries, conflicts rules were the sovereign prerogative of the modern nation state, ultimately a matter of comitas. And in Europe, this is now all coming to an end. Conflicts rules are no longer made by the various states for themselves, nor are they agreed upon among co-equal sovereigns. They are now made by higher institutions and imposed upon the nation state, from cooperation to command. That spells the end of the traditional order, and that's a revolution. Is this centralization and unification of European conflicts law a worthy model for the United States that we seek to emulate? Now, if I wear my German hat, ignore the Reimann tours, that was a joke that friend of mine's playing on me. If I wear my German hat and consider the question from a logical point of view, the answer must plainly be yes. Logic suggests that a federation in which the member states have diverse private laws should have a centralized and uniform rule to determine which of these laws apply in transboundary cases. As Jürgen Basedow put it, the states are the players and they need a neutral referee and, one might add, a common set of rules. In contract and tort, not in other areas, but in contract and tort, there is no such common set of rules in the United States. Instead, each state does pretty much what it wants. And regarded from a German, and perhaps European perspective, this just cannot be right. The United States should also come up with a centralized and uniform choice of law regime in the form of federal legislation. In short, the United States should follow the European lead. That's the only right thing to do. Yet, if I wear my American hat, I'm much less sure. because I'm thinking more pragmatically, practically, and even politically about this. On this very campus, Brainerd Curry, about 50 years ago, opined that Congress should legislate concerning the choice between competing state interests, but I see several reasons against that. While some of these reasons make me skeptical vis-a-vis even European choice of law legislation, I will focus here on the situation in the United States. And in particular, I have three concerns. First, the actual need for centralized choice of law rules strikes me as vastly overrated. Second, one must doubt whether the United States Congress had the capability to produce choice of law legislation worth having. And third, choice of law legislation European style would be at odds with some important features of the American political and legal culture and would not at all guarantee actual uniformity of outcomes. So let me address these 3 points. First, need. The need for uniform choice of law rules, I think, is not nearly as obvious as one might think. Let me just focus on the needs of the market here and leave the legal profession aside. Do market actors need uniform choice of law rules, especially in the areas in which we in the United States don't have them, that is contract and tort? In contract, uniform choice of law rules, I think, aren't nearly as crucial to the functioning of the market as one might at first think. First, commercial actors generally write their own rules in extensive standardized contracts. Second, most written contracts across state boundaries today contain a choice of law clause, and once these clauses are enforced, and that's a very important rule, it almost is routinely enforced, objective choice of law rules don't matter anymore. And third, at least in the United States, contract law is fairly uniform throughout the country, so that selecting this or that law makes a real difference only in the exceptional case. In other words, as a result, uniform choice of law rules for contracts matter only if, first, the issue is not addressed in the contract itself, second, if there's no choice of law clause, and third, if the underlying law is substantially different, and those cases will be quite rare. In tort cases, choice of law rules come into play much more often. There's usually no opportunity for the parties to write their own rules, that is, to agree upon them ex ante. In addition, at least in the United States, tort law is now highly fragmented. In other words, choice of law rules are rampant in transboundary torts, and they often are highly outcome determinative. That suggests that uniformity of tort choice of law rules is essentially for the market. Yet again, closer inspection reveals that for market actors, such uniformity really doesn't matter all that much at all. Again, there are 2 reasons for that. One reason is that choice of law, as others have pointed out, is not nearly as important for market actors as we conflicts lawyers tend to think. Transboundary cases comprise a very small portion of all tort cases. What really matters to most market actors and their liability insurers is the local substantive tort regime, because that governs the vast majority of all cases. For these actors, not being able to predict the outcome in the occasional transboundary case is a minor nuisance. That said, there are important exceptions to that, because some commercial actors operate in a transboundary context routinely. They find themselves in transboundary torts all the time. Airline companies, rental agencies, trucking companies, motel chains, manufacturers of consumer goods, they're repeat players, and that, of course, includes their liability insurers. These actors have a real and significant interest in predicting outcomes in transboundary cases, and thus, arguably, in uniform choice of law rules. This brings me to the second reason why uniform choice of law rules is of limited importance. They cannot significantly enhance the predictability of actual outcomes. This is because, for market actors, operating on a nationwide basis, it is extremely difficult to predict where disaster will strike and whom it will involve. That, in turn, creates a pervasive factual uncertainty that overwhelms any predictability even uniform choice of law rules can possibly provide. Take the position of an automobile manufacturer in Detroit, Michigan, which sells cars all over the nation and, of course, abroad. A possible defect can lead to lots of accidents in lots of states involving lots of parties. That will inevitably lead to the application of lots of different laws. Diverse choice of law rules contribute little to that problem, and uniform choice of law rules can do little to remedy it. Even if the whole country subscribed to the crudest of tort choice of law rules, the lex loci delicti, that manufacturer would still be faced with a multitude of laws and states and unable to predict outcomes across the board simply because the choice of law rule replicates the factual uncertainty underlying that business. And as soon as, let's say, uniform choice of law rules engage in a little bit of fine-tuning, for example, by adding a common domicile exception, it makes outcomes even less predictable because now the choice of law rules replicates also the randomness of the involved parties' origins. In sum, for most market actors, tort choice of law rules are in and of themselves of very limited value. Market actors understand that full well. Note that they do not waste their time and resources lobbying Congress for uniform choice of law rules. It's a matter far too unimportant for their perspective. Those dealing mainly with local accidents do push for reform, for substantive law on the state level. And those regularly facing multi-state torts also seek federal rules with a preemptive effect, because that's the only thing that creates nationwide uniformity and thus gives them the predictability they want. What about forum shopping? Well, it's true, of course, that diverse choice of law rules increase forum shopping. That's an argument in favor of uniform rules. But even that argument shouldn't be overstated. Forum shopping is mainly a problem in tort cases, but there's reason to doubt that the current diversity of choice of law rules plays as great a part as we tend to believe when we focus on the few cases where we see it happening. To begin with, diverse choice of law rules allow forum shopping for favorable substantive law only if they actually lead to different results, which is not routinely true at all. Actually, in most cases that we heard from Sim this morning, they do lead to very similar results, regardless of their description. Furthermore, much and probably most forum shopping is not motivated by diverse choice of law rules, leading to the application of diverse substantive laws. Most plaintiffs' lawyers aren't sophisticated enough and don't have the time resources to consider all possible jurisdictions and all their possible choice of law rules and all the possible laws that might lead to. Most plaintiffs' lawyers and their clients simply want a home game, be it for reasons of convenience or because they suspect some kind of internal advantage. When they sue away from home, they usually do it to avoid statute of limitations or other favorable procedural law on which, by the way, the rules are actually uniform indeed. Uniformity here promotes forum shopping. It does not defeat it. Now, to be entirely clear, my argument here is not that uniform choice of law rules are a bad thing. It is that at least in contract and tort, they're not crucial for a functioning market, at least under United States conditions, and they cannot possibly be justified on that ground. Beyond that, they do have a lot of salutary effects. So if we can have good choice of law rules, we should want them, quite regardless of market needs. The particular problem is in the United States, and this brings me to my second point, that we probably cannot have good choice of law rules, at least not European style, that is in the form of federal legislation. The main problem here is the question whether Congress could be capable of producing choice of law statutes worth having. I suggest the answer is no for three reasons: lack of political will, lack of substantive consensus, and lack of legislative skill. In all these regards, by the way, the situation is very different from Europe. The first point, lack of legislative will, I do not want to belabor. Jürgen Basedow just mentioned it. There is no political will to unify choice of law rules as a congressional matter. That's not only because it's a technical area, it also reflects the lack of interest and maybe the lack of a perceived need. There is also, of course, the lack of substantive consensus. Even if there was political will to push for federal choice of law legislation, the chances of reaching consensus of what they should look like is fairly close to zero. In part, this is due to the inability of Congress to agree on pretty much anything outside the realm of politically hot items that promise immediate media attention and voter favor. In part, the near impossibility of consensus is also due to the continuing disagreement among practitioners and academics about choice of law. One cannot fairly expect Congress to overcome these deeply rooted and long-standing disagreements, nor would it be proper and prudent for Congress to resolve them by legislative fiat. And last but not least, even if we had the requisite political will, and even if we had a basic consensus, Congress would probably not be able to produce a choice of law statute worth having. To some extent, the problem is simply lack of drafting skills, but the main problem lies somewhere else. Even if Congress was supplied, perhaps by the American Law Institute, with a decent draft, that draft would almost inevitably be revised beyond recognition during the legislative process. Lobbying and log rolling virtually ensure that statutes become filled with minutiae to please this or that constituent, riddled with exceptions to placate this or that lobby, and burdened with writers to ensure the support of this or that faction. Take the example, stuff Linda's familiar with, of the Multi-Party, Multi-Forum Trial Jurisdiction Act or the Class Action Fairness Act, and you know what we have to expect. Here, Congress turned relatively simple, straightforward ideas into statutes of enormous complexity, into a labyrinth that almost nobody can penetrate. In other words, a congressional choice of law statute would produce uniformity only at the cost of enormous complexity and unwieldy length. Such a statute would neither facilitate the work of legal professionals nor improve market actors' ability to predict actual outcomes. My third point is that a uniform legislation on the federal level would also not sit well with some basic features of the political and legal culture of the United States. These differences here in regard, again, to Europe make it a very dubious business to take the European developments as a model for the United States. They pertain mainly to the nature of the respective legislative processes, to the conceptions of federalism on both sides of the Atlantic, and then we must add a third difference, namely the varying degree to which uniform rules actually determine uniform outcomes. The legislative process in the European Union and the United States present different trade-offs between effectiveness and democratic input. When we look at the European developments from the American perspective, we should take these trade-offs into account. The legislative process in the European Union is initiated and steered by non-elected policy and lawmaking specialists in the Commission. It also involves then agents of the member states' executives and the Council, and finally, popularly elected representatives in the European Parliament. It is in essence a bureaucratic process of expert lawmaking with some fairly limited democratic input. Since these institutions can settle all differences, so to speak, within the family, the legislative process can be quite effective in the sense that it gets things done. But the price for this effectiveness is a disconcerting lack of democratic input. The legislative process in the United States, especially in Congress, is much more open to direct political input and much more subject to media and public scrutiny at every turn. Unlike its counterpart in the European Union, it is not haunted by the specter of a democratic deficit. But it is very openness subjected to interference by myriad political interests from many quarters. They pull in all sorts of directions, and as a result, legislative efficiency is very low. Projects get bogged down, process is not very effective, often it just cannot get things done. The point here is not to render a value judgment about this or that legislative process. It is rather to sound a note of caution that Americans who envy Europe for producing uniform choice of law legislation should remind themselves that the European accomplishments come at a cost Americans would probably be reluctant to pay, even if they had a choice. It's hard to imagine that Americans would want uniform choice of law legislation badly enough to put up with the bureaucratic lawmaking that produces it in Europe. Another condition for effective unification through central legislation is the will of the central authorities to take over areas of law which, like conflict of laws, have traditionally been the domain of the member states. In the European Union, the central level is taking over almost whenever it has the power to do so, sooner or later. It is but a slight exaggeration to say that it unifies when and because it can, and that's quite intentional. These takeovers do not necessarily reflect merely the thrill of exercising power. They also express a deep general penchant for legal uniformity, which the Europeans tend to see as an almost unqualified good. The United States, the central level takes over mainly when and because it needs to. It is again only a slight exaggeration to say that we unify when and because we must. Even if there is a need for unification, we often still leave it to the member states first to pursue that, mainly by adopting model laws. This does not necessarily mean that central authorities in the United States are less power hungry than those in Europe. Rather, it expresses a greater tolerance of and perhaps even preference for legal diversity. In the United States, uniform rules are just not that important in law because Americans are generally much more indifferent to messiness. All this shows that, at least in the area of private law and procedure, federalism in the European Union today is weaker than in the United States. Of course, if there is sufficiently strong need or enough political pressure for centralized and uniform rules, Congress will not hesitate to make them. But in contrast to Europe, there's no presumption of such a necessity, and there's no overall preference to centralize and unify. There's a final reason why Americans preferring greater uniformity in choice of law should hesitate to consider centralized legislation European-style model. In the US-American legal culture, even uniform rules would not create nearly as much uniformity of results as in Europe. One thing is that the rules themselves would not be as hard and fast. You need only look at the second restatement or at the choice of law legislation that we have now in some instances at the state level to see that. And more importantly, they would not be taken as seriously by the judiciary. European judges are trained in rule obedience to a very high degree. Our judges are not. They will take much greater liberty with it. Note in particular that there would be no institution in the United States effectively to police adherence to uniform federal choice of law rules. The United States Supreme Court, which hands down fewer than 100 reasoned opinions a year, would not have a chance to ensure uniform interpretation and application of federal choice of law legislation, even if it wanted to, which is unlikely to begin with. In conclusion, Nothing that I've said is an apology for the status quo in the United States. But I think the main problem in American contract and tort choice of law rules, as well as the main cause of forum shopping for favorable substantive law, is not their lack of uniformity. It is rather their lack of neutrality. Although conflicts adjudication today is probably more even-handed than it was a decade ago, at least that's what I gleaned from reading annual reports that SIM delivers, there is still very much room for courts to prefer their own state's laws and to favor local litigants. The conflicts revolution has, of course, hugely exacerbated that bias, and the United States Supreme Court has by and large failed to curb it. This is a serious problem, and its solution would be to outlaw choice of law rules or results that discriminate against other states or their citizens. Constitutional instruments for that are not lacking. The United States Supreme Court's relative inaction in this regard stands in marked contrast to the emerging conflicts jurisprudence of the European Court of Justice, which is more elaborately described in Jürgen Basedow's paper. There are indications that the ECJ is taking the constitutional constraints, principles of freedom of movement and of non-discrimination on conflicts issues quite seriously. If American conflicts lawyers want to learn from current European developments, they should watch the work of the court in Luxembourg, rather than follow the somewhat obsessive uniformity agenda of the Commission and Council in Brussels. But that's a topic for another paper. Thank you.
The coveted last paper slot of the day. Is everybody still awake? I'll try to be quick with this. So Larry's and my paper sort of bounces off a normative perspective on choice of law that's maybe unique to many of you. So I'm going to spend a few minutes kind of setting up what that perspective looks like and to enable Larry to talk about comparison between the European Union and the United States. So we start off in this paper by taking the position that choice of law in the United States is actually characterized by two revolutions. One, which has been well documented elsewhere as well as here today, is the move from formalistic rules to more realist standards for choice of law purposes. But the second, which we argue is going on today, is what we call the emergence of a law market. And that is that there is a law market that is states competing with one another to provide laws that are appealing to people and their assets because of a massive increase of mobility. People can move borders, their assets can move borders, their firms can move borders. And as a consequence of this mobility, people and firms are much better able to choose the governing laws that control their activities than they ever have been in the past. And even if they can't choose a particular governing law by locating their assets, locating firms, they can at least avoid laws they don't like through the location of those assets, firms, et cetera. So we've got this law market developing across the world. We're going to argue that in general this law market is a good thing, that it's a good development, but that in certain places it is posing problems. And so the question becomes how to develop a set of choice of law rules that can facilitate the law market where it produces good results, but yet enable states to be able to shut down the law market in order to mitigate its costs where necessary. Okay, and so just to be clear, our normative take on choice of law is that choice of law rules should be those that promote lawmaking procedures that maximize the chance that we'll get to efficient substantive laws that would be enacted in each state. So, you know, we can all think of procedures, you know, democracy, majority rule, that enhance the value of laws in general. And sometimes we focus on those procedural rules precisely because it's so hard to figure out what's a good set of substantive laws. So we've got this goal to end up with efficient substantive laws, as we have this goal, Larry and I, to end up with efficient substantive laws in the sense that their benefits exceed their costs. But it's often very difficult to figure out what a substantive law would be. So Simeon and I could disagree for the next 3 hours about whether franchise regulations are a net good or bad, and we might not convince this group one way or the other at the end of the day. Okay, so if you start from the perspective of public choice theory, the way you get to good laws from a procedural perspective is to try to maximize the participation of those who are affected by a law, who have a stake in a law, who care about a law. If you look at public choice theory from the, as developed in the 1970s and 1980s, according to that story, there's a lot of defect in legislatures when it comes to the passage of laws because some interest groups are much better able to organize and mobilize themselves to influence legislation than are other interest groups. And in particular, if you have a law that affects outsiders, because legislators focusing on re-election have to pay more attention to their constituents, those outside voices can end up being shunned to the point where you end up having laws with negative external effects. Those costs don't get taken into account. Okay, so, and even if the legislature does a good job taking into account costs and benefits in general, if you don't have maximum participation and therefore you don't have full information, there always is this risk that the legislature ends up being well-intended but passing bad laws just as a consequence of a deficit of information. Okay, so our argument is that the law market, this ability to move yourself and your assets to get to better laws, helps mitigate some of those defects that we might see in the legislative process. So what would be the benefits of a law market? Well, first, exit produces alternative to voice, right? If you can't have your interests represented in the legislature, but you can move yourself or your assets so that you're not subject to the laws that result, it might be okay that you don't have voice. Exit, in turn, can create voice. That is, once people and their assets can leave a jurisdiction, exit-affected interest groups in that jurisdiction, that is, those people who benefit from the assets and the people being in the jurisdiction, are more likely to mobilize themselves to represent those outside interests. Third, a law market can minimize the cost of bad laws. So here, even if you have enough voice to influence a legislature and the legislature taking into account everyone's views passes a law, if that law turns out to be a bad law, you can get out from under that law. If you can get out from under that law fairly cheaply, then the costs of bad law go down. As a result, legislatures are more willing to experiment with law reform because the lock-in is smaller if people can move if it turns out an experiment hasn't worked very well. And fifth, the law market can facilitate a better fit between law and diverse party needs. So it may well be that the legislature takes into account all of the interests, that the legislature ends up with an efficient law in the sense that it does serve the majority of parties in the jurisdiction, but it might turn out that a majority of people in the jurisdiction find that they having completely different set of needs or interests, that the law doesn't serve them, and the ability to move helps them get to a better fit. Okay, but any law market's going to have costs. So sometimes this jurisdictional competition provides third-party externalities. That is, if you can move to another set of laws, it may well be that the state finds it hard to protect the environment. The state finds it hard to protect other third parties left in the jurisdiction whose interests aren't represented. And second, sometimes when parties attempt to use the law market to get to the law they want in the context of contract, that leaves the state unable to protect a weaker contracting party. We've been talking about employees, consumers, et cetera, here today. Okay, so we've got benefits of the law market, we've got costs of the law market. We could have another debate for the afternoon about whether on net with a particular law we need to worry more about the benefits or the cost. So again, we're looking for procedural mechanisms that would, on average, increase the benefits, minimizing the costs. So what would be the elements of a set of choice of law rules that would promote healthy law markets? Okay, well, we'll start first with this idea that choice of law clauses should be enforced. That is, especially if we're talking about sophisticated parties, freely negotiated contracts, choice of law clauses allow parties to avoid bad laws and get to a better fit for their contract. Second, we would want choice facilitating rules, right? So when we don't have any choice of law clause in a contract, we argue that good choice of law rules, that is those that facilitate the benefits of the law market, would be rules that are clear rules that provide ex ante notice to the parties. And they're clear rules that end up allowing the parties to, in effect, make a mutual choice with regard to their governing laws. So take, for example, product liability laws. if you have a choice of law rule that says, we'll apply the law of the place of the manufacturer, that could be a very clear rule. It could be a clear rule that everyone knows ex ante, but by designating the law of the place of the manufacturer, we don't get mutual choice, because now firms can locate their plants where the law is that favors them. Whereas a place of sale rule might be a clear rule, and a clear rule that might enable at least a better opportunity for mutual choice between parties. Okay. And then when litigation is not planned for, we argue that we need a good set of default rules that line up roughly with what Posner refers to as the comparative regulatory advantage, or effectuating the comparative regulatory advantage. And so here the idea is just to assign lawmaking authority in a way that's sensible, that doesn't create crazy surprises. We've got jurisdictional authority where it most makes sense, and therefore we can control the external effect of laws. You know, obvious examples would be in a car accident, you'd probably want to start with the law of the place of the accident. If you're thinking about intra-family immunity, you probably want to look to the law of the domicile, the common domicile of the parties, that kind of thing. Okay, and then essential also to the choice of law rules has to be a mandatory override, right? It has to be the case that when states say, we've got a law, the law is here to protect our parties or our citizens or our environment, and it's an important law to us, the state needs to be able to shut down the law market to insist that its laws be enforced. Typically in the United States, this takes the form of the public policy exception. And the problem with the public policy exception is that as we use it in the United States, it's never clear which states get to invoke the public policy exception or under what circumstances a state might invoke the public policy exception. So our view is that healthy choice of law system, of course, has a public policy exception, enables a state to be able to insist on the application of its own law, but probably should be done through legislative rather than judicial means. Why? Because when the state passes a statute that says, here's the regulation and you can't opt out of it, or here's the regulation and to the extent that we see an influence on our people, our firms, we insist on its application, then we're providing notice to parties about what the ultimate outcome of that law might be. The other thing, too, is if you go back to this public choice theory of the 1970s and 1980s, it isn't taking into account the fact that exit-affected interest groups are becoming very popular in state legislatures, right? So outside interests are being protected much more in state legislatures, and in the process, because exit-affected interest groups tend to be anti-regulatory, my own view is we're seeing more consumer representation, more consumer groups forming and organizing themselves in the legislature. And so it may well be that we've got a much more healthy legislative environment today than we did 20 or 30 years ago, and so therefore it's the right place to talk about forming public policy exceptions. Also within the United States, Larry and I, in a book that's forthcoming, we talk about the fact that federal courts, because if you take sort of enforcement of choice of law clauses, for example, federal courts and state courts are not enforcing choice of law clauses at equal levels or percentages. So federal courts, when they sit in diversity, have to apply the same choice of law rules in the United States as would be applied in the states where they're located. But because the second restatement standard for enforcement of choice of law clauses is so vague, that gives discretion to the federal courts to decide whether they want to enforce choice of law clauses or not. So if you've got the states through legislative form passing a clear statute saying, no, we're going to pass this regulation to protect franchisees and you can't contract around it, franchisors in your contracts, that legislative statement is a statement that would have to be followed by the federal court. So the legislative mechanism, at least within the United States, would also serve this extra function of enabling the state's policy or insisting that the state's policy be enforced even when litigation occurs at the federal level. And then fifth, the system needs a federal law backstop. So if a state interferes too much with the way the law market functions, or if the state provides too much competitive pressure that makes it hard for other states to have effective public policies, then the federal government becomes a possibility for stepping in to correct the movement too far in one direction or the other with regard to the law market. Okay, so if these are essential principles for a good choice of law system, how does the U.S. fare? not very well. We don't have clear rules for choice of law. We've got 6 different approaches in the United States. Most are vague and multi-factored. Enforcement of choice of law clauses, a fairly vague standard as a consequence of this very vague public policy exception. And as has already been talked about on this panel, the federal government's essentially abdicated its supervisory role here in the United States with regard to choice of law. So then could the new European model help us out of our choice of law chaos? And to answer that, I'll turn this over to Larry.
Okay, well, so I'm the last. And I think we've had something like 15 papers. And I want to talk about where we stand in all these 15 papers in a second. But first, I'll be the last person to thank Ralph for putting this together. Really appreciate the invitation. I almost feel like it's fated for me to be here because I took conflicts from David Curry, and then my first teaching gig was at Mercer Law School, which was the first home of Brainerd Curry. And in honor of Brainerd Curry, Mercer had a law review symposium about 10 years ago, which Erin and I contributed to as the beginning of our work on the law market. And so here we are at Brainerd Curry's home at Duke. So it's kind of fitting to be here. So you've had these 14 or so or 15 papers. And I'd like to sort of characterize all this as the introduction to our work here, because we think that all these rules, all they really amount to is kind of the background for, as what Erin referred to as the law market. You know, I have to say, this is, well, I mean, one thing I'd like to thank Ralph for is this is the best choice of law conference I've ever attended. It's also the only one. But I'm sure it would be the best even if I had attended a lot of choice of law conferences. But I have to say that I feel a little bit like an agnostic or a peanut vendor or something at a Baptist convention. You'll notice I'm the only speaker who's not wearing a tie, and actually I planned it that. I didn't plan for everybody else to wear a tie, but just to show my difference here, because I'm not, you know, I really feel like there's been all these religious symbols and so forth. We have Saint Savigny and Mancini, who I always thought was the author of Moon River. We have, we even have choice of law jokes, you know, like the European choice of law revolution. Every time somebody says that, there's a big laugh. You know, what did I know? You know, again, I sort of feel out of it because Erin and I really have our own way of looking at this whole choice of law phenomenon, again, as a market. And we apply market theory and public choice theory, and all this other stuff that's going on is kind of in the background. I also have my own way of characterizing all the stuff that's gone before in terms of the issues. And by the way, you did distribute the slides in hard copy, or somebody did, right? Okay. I'm not bothering. It's the last presentation, so I'm not going to put it on the screen. But this stuff that I'm saying is sort of introductory to the actual slides. But a few dichotomies that I see in the literature in terms of where we fit in all this. First of all, a dichotomy between a static and dynamic approach to choice of law. So a lot of what we've heard today is let's look at the rules as they are and comparing the European rules as they are with the American rules as they are. In the book is primarily my work with Erin is primarily a dynamic approach. In other words, we're showing how things got to where they are, and the answer to how they got to where they are is by this process that Erin referred to as mobility, creating, you know, the threat or actual departure of people from jurisdictions creates an incentive. Well, it creates these exit-affected interest groups that then put pressure on the legislature to either enforce choice of law or change the substance of rules. So that's the dynamic process that we're talking about, which, again, I'm contrasting with the static idea of what the rules are today. also a distinction between institutions and rules. So the question is, what are the actual institutions that drive this dynamic process, as opposed to the rules, which I think are only part, the choice of law rules, which I think are only part of the overall institutions that drive the process. And then the third thing is, I know that our assignment for this conference was, what are the lessons of Europe for the U.S., which has a normative sort of tinge to it. Is Europe better than the U.S. or worse? But, I see our project, we see our project as primarily descriptive, actually, as a positive project. In other words, this is what's actually happening in the world. And to some extent, we are normative. So we asked the question, as Erin said, of what institutions would better get us to where we want to be in terms of the law market functioning. But predominantly, you have to get, in order to really develop those things, you have to first understand what's happening. And I think there's an inadequate understanding of what's actually happening, which we're trying to, and that's a gap that we're trying to fill. Now, finally, in terms of the dichotomies that I see, probably most importantly in terms of the lessons of Europe for the U.S., I have to start introducing a Freudian analysis here. So you have the European anal approach and the U.S. Oral approach. The anal approach is very rule-oriented, and we've talked about the conventions and the ECJ rules. And a lot of what, I'm going to be short now because a lot of what I had to say has actually been taken up by previous speakers. But, we've heard a lot of the description and analysis of the Rome 1, Rome 2, Rome 3, and so forth. That's sort of the anal uniformity approach and the federal rules on choice of law. And as many speakers have said, if there's a lesson from Europe, that's the lesson for the U.S. And as other speakers, including Mathias just now, have indicated, maybe that's a lesson that the U.S. isn't going to learn because the U.S. isn't set up for that, because we are basically an oral approach of chaos, mess, and so forth, not getting the room in order. And so I think that's the major contrast between the U.S. and Europe. So the first slide, so we're getting to the slides. The first slide is about the European anal approach and just summarizes some of the rules that we've seen today, focusing on the rules that are relevant to the law market. So in other words, the rules particularly on party autonomy in Rome 1 and Rome 2. Somebody objecting to my Freudian analysis here? Okay, fine. So that's the first slide. And then the second slide is about the U.S. oral sort of chaotic approach, and the fact that, as many people have pointed out, we just don't have, our constitutional rules aren't set up for disciplining the chaos and bringing order to choice of law, even to the extent that the ECJ has in those cases. And we don't have, all we have is DOMA in terms of federal choice of law, which isn't much. So that's an indication of how the U.S. has failed to bring order out of the chaos. Now, the problem. So now the question is, what are the lessons from the anal European mode to the U.S.? Well, one problem is that there's an inherent limit in the extent to which, and this isn't really a criticism of Europe, it's just sort of a positive observation. There's an inherent limit in the extent to which you can really order choice of law, because you're always going to have to leave the door open for mandatory rules that override autonomy, party autonomy, in countries that have regulatory authority. So it's going to be very difficult to have one clear rule that says exactly when companies can regulate and override choice of law autonomy and when they can't. And I have a slide about the limits of EU protection on contractual choice. And but again, that's not intended to be a criticism of Europe, because I think that there are inherent limits in the extent to which you can bring order to this area. So, but then the question is the U.S. really, the chaos of the U.S., the oral approach in the U.S., really so bad? And here we get to the dynamics of the law market that Erin talked about, and I focus a little bit in my area here about the exact institutions in the U.S. that may be different from the institutions in Europe vis-a-vis helping along and facilitating a law market. So Erin talked about the role of mobility. There's just more mobility in the U.S. I mean, partly this is linguistic and cultural. It's just like, there's no difference in Kansas and Nebraska, let's face it. And so you can move between those countries. It's not like moving between, Germany and France.
Kansas has Fred Phil.
Okay. You live there. You live in what? You live in either Kansas or Nebraska, and I know. And so you know very subtle differences between the two, but they're not really important. And and that's part of it. There's common constitutional provisions across the U.S. states. You don't really leave much behind when you go from one state to the other, in addition to not having as much to have to adjust to. And again, as we've said, mobility is one of these is one of the key factors that drive the law market, and it's the alternative to a political dimension. In other words, if you want to change the law, you can do it either by exit or voice, and U.S. just offers a greater exit dimension to affecting law changes and actually choosing the law. Okay, and then Erin referred to the federal law aspect here, and the idea here is that, well, I mean, we've seen that the federal legislature in Europe, so to speak, operates over a much slower pace, a much more relaxed pace than I think these directives that are enacted in Europe than U.S. federal law. I mean, it only takes about 10 minutes to adopt a U.S. federal law, as we saw with Sarbanes-Oxley. I think that was about 8.5 minutes, which could, at one fell swoop, override a lot of state corporation law. But I don't want to focus on Sarbanes-Oxley because that's kind of counter to my point. My point here is that to the extent that there's chaos in the law market, you're going to get a lot of agitation from companies that have to actually do business in this chaos, and they can go to the federal legislature and get a law that protects them from the chaos of the law market. And this operates as a very powerful disciplinary force on state chaos. Because the states know that unless they get their act together in terms of coordinating and imposing diversity-type costs on companies, that the federal government's going to come in and bail the companies out with a federal law. So that's a disciplinary force that I think operates much more quickly in the U.S. than it can operate in Europe. And it's one of the main institutions, I think, of driving the law market. So, but there are also other things. There's the procedural protections, I think, of the law market. Erin referred to federal diversity jurisdiction, which provides a forum for escaping U.S. courts state courts that might adopt law market unfriendly rules. Now, it's true that Claxon says that the federal courts have to apply the same choice of law rules, but they don't necessarily have to apply them in the same way. And I've done a fairly extensive study a few years ago of looking at 700 cases that adjudicated choice of law clauses and found that the ratio of enforcement, Claxon applies, but the ratio of enforcement is much higher in federal courts than in state courts. Again, applying the same rules, and that's diversity jurisdiction, I think, operating as a disciplinary force on the state chaos in the U.S. Again, all of these institutions supporting the law market in the U.S. Okay, so what are the lessons here? Well, you do have more order imposed from the top, the anal kind of approach of Europe. You do have institutions of the law market operating better in the U.S. It's possible that, kind of taking a normative perspective now, what can we really learn in the U.S.? It's possible that the U.S. could adopt at least some top-down European-type approach. What we're looking at here overall is, what out of our total legislative toolkit, what kinds of laws will best support the law market? So again, we can take some tools from top-down uniform lawmaking. Erin and I, in our book, propose a federal choice of law statute. Now, we've already heard from Mathias that can't happen, that this is an impossibility and it would be ineffective. Well, in fact, I think we have an approach that might happen. I'm not saying it's likely, but if it did happen, I think it would be effective because it provides a political mechanism for distinguishing between the mandatory overrides and and where state laws don't override choice of law. And the political mechanism is force the state legislature to articulate that, in fact, this is what we call super-mandatory law. In other words, a law that overrides choice of law clauses. Don't leave it to the courts. Force the state legislature to make this articulation. Provides more predictability, and it also provides a better mechanism for exit-affected interest groups to get law market-friendly kinds of rules. At the same time, so that's a kind of top-down approach to support U.S. law market institutions. At the same time, maybe Europe could figure out a way to adopt some of the law market-friendly institutions in the U.S. But again, that's as far as I want to go normatively, and it's not very far. I think positively there's more lessons from our analysis for Europe and the U.S. Is to start thinking more dynamically about the choice of law rules that have developed both in the U.S. and in Europe, and particularly in Europe. So we've seen earlier today, we heard talks about family law and same-sex marriage, which is something I've written a couple of articles about. And but from my standpoint, the question is, what drives the market in marriage laws? And to some extent, you can talk about exit-affected groups. I mean, some states will want to attract couples that want same-sex marriage. Some states may want to repel them because the pro-regulatory groups in the state may have more power, more political power, than the exit-affected groups in the state. Of course, the U.S. Federal law has kind of short-circuited that, and DOMA, I think, has short-circuited that process to some extent. But that's a study of how does jurisdictional. That's again a dynamic approach. How does jurisdictional choice? How does the law market actually work? And I think that could be a useful dimension to study. Erin and I have a current article on the internal affairs doctrine. It's not about whether it's a race to the top or a race to the bottom, but how did the internal affairs doctrine actually develop? And the answer is it actually developed through mobility and exit-affected interest groups in the U.S., which I think contrasts a little bit with the top-down approach of the ECJ and Centros in Europe. But I only think that because I haven't really studied the European development of these rules nearly to the same extent as we've studied the U.S. development. So I think that's also a potential kind of item on the research agenda. So again, I mean, I'm urging you to think about the law market perspective in all this. I don't think it's a perspective that's arisen, today before Erin stood up, a half hour ago or so, and I think it has some interesting lessons for not only for the U.S. but also for Europe. So thank you.
Thank you very much. We will have two discussions now. We will have one discussion of 20 minutes on this panel, and then Professor Ribstein actually has to leave us. And at that very moment, we will turn the discussion over to just a general discussion in which everyone can still say what they want to say, and then we'll finish sharply at 6:30, so we'll get out well-deserved.
So you can reserve your criticism for like 20 minutes or so. With me.
So anyone has reactions to anal versus oral approaches to choice of law? Yeah, we can also start with the panel.
Yeah.
Yeah.
Well, first thing, I like the idea of the law market. That's not a problem. First idea that comes to my mind is that if choice of law can be explained in this way, then the Claxon decision means cartelization. There are within one state there are two types of courts. One court offers state law, state choice of law rules. The other one has offered before Claxon federal choice of law rules. And at one point in time, the Supreme Court says, from now on, state courts apply, federal courts apply the state choice of law rules of the state where they are seated. This means that there is no longer competition between these. Exclusion, so federal antitrust laws should be applied against Claxon. But one more serious remark.
Well, yeah, I'm with that. Okay, so.
A more serious remark. I think the idea is very valid for and can explain certain phenomena which we can observe, like in the field of corporations. I think it is perhaps already less valid in contract law, at least from an empirical point of view. You would expect choice of law clauses in contracts to reflect somehow the competition that exists between various national laws. Now, we tried to look up at our institute the various guidebooks for practitioners on how to draft contracts. And we did that for Germany, France, and England. And what is surprising is they always say, don't forget to choose German law, French law, English law. They never ask whether perhaps the foreign law might be more beneficial to the party who is now, or for both parties perhaps. This is not, they just say, don't forget to make a choice of law. So there is apparently, my explanation for that is that there is a principal-agent problem. The lawyers who are dealing with that, they have their own interests. They want to have, when they give advice on the conclusion of a contract, they know that certain litigation may arise out of that contract, perhaps only in one contract out of 100,000. But in that case, they know, well, this contract will be litigated under my law, so there is a good chance that I get the job for it.
Well, I mean, partly that's a problem with Europe that I was pointing out, is the cultural and linguistic differences that impede mobility. Partly it may be a principal-agent problem in the sense of the lawyers wanting to choose friendly law, and that's been studied and so forth. But I mean, if you compare what's going on there to Ted Eisenberg and Jeff Miller's work on choice of law, I mean, they show a massive move, for example, of contracts all over the place to New York, to choosing New York law. Not choose Kansas or, Nebraska or whatever, even if that's where they're located, but, choose this contract-friendly jurisdiction. So I haven't actually studied choice of law clauses in Europe, but that's a good, that's another item on the research agenda to show, that they differ, and I'm not surprised that they differ.
Yeah, and it kind of depends, in the United States, it kind of depends on the type of contract, right? So if you see a franchise contract, inevitably the choice of law clause picks the law of a state that's not regulating franchisors right now. And if you see a merger agreement, they tend to pick Delaware law. Commercial contract tend to pick New York law. Interesting, picking New York law and more commonly picking New York federal courts. So they want the law of New York, but not actually the courts of New York State. So sort of fine-tuning in that sense. But, you know, I'm studying the CEO contracts between CEOs and the firms, and they all have choice of law clauses, but we can't find a pattern one way or the other. I mean, it seems to be, you know, wherever the company's headquarters are, that's whose law they're picking. That doesn't seem to be a strategic move.
I've looked a little bit into this because I was interested why in the United States the CISGs routinely opted out of. And my explanation for this is in part it's an agency problem, but in part it's also a transaction cost problem, because in order to make an intelligent choice of law, you have to know what you're choosing. And the research is enormously costly unless you do it so routinely that you know what you're going for. And it's a prediction problem because in most cases you don't know where the issues are going to be, and most contract laws will have some advantages and some disadvantages. So if you and I knew in our contract what the bone of contention will, where the fallout will happen, sometimes you can predict that, but often you can't. It's very difficult to research all the possible laws, predict what the issues will be, and then say where you would come out best, and then put that to the other party. Transaction costs are so overwhelming that in most cases not.
Well, but I mean, what you're choosing is the most reliable jurisdiction, you know, across all cases. So that's New York. I mean, New York is a
right,
relatively conservative.
But if there's a clear choice like that, I think you see it. But if the choice is between you're sitting in Nebraska and you choose Nebraska law or Kansas law or Missouri law, I mean, it's just at some point it's such a crap shot at that level.
But that's what the states are competing for, is to provide, you know, to stand out in terms of that reliability. That's how Delaware wants to work.
This is a good reason for it, right?
Right.
You choose it, but
I give you
And if there's
an
a real
example,
difference.
commercial agency, which is probably very close to what you call franchising. In Europe, we have mandatory provisions which give a right to a post-contractual indemnity to the agent. Now, the amount of this indemnity is, in Germany, a maximum of 1 yearly commission. In France, it is a flat rate, so to say, 2 yearly commissions. So there would be a strong incentive for French franchisors to choose German law, because that would mean that after the end of the contract they would pay less. That's never done.
What about location of assets? So, for example, in the United States, Congress passed this National Banking Act that says that the bank can charge any interest rate, and now that means like late fees and other charges that are permissible where the bank's located, right? So, as a consequence of this, the credit card companies all run to Delaware. As the first in South Dakota were the first 2 states to get rid of usury laws, and now they've got, you know, unlimited ability to charge interest rates and fees protected by this congressional statute. The states can't do anything about that. Do you see that kind of movement at all in Europe, where the EU sets up that type of rule and assets are locating?
But that has not been the object of EC legislation so far.
Okay.
The amount of interest and so usury laws, there is nothing. I mean, there are certain consumer law directives which one on abusive contract terms in consumer contracts, they may be applicable, but there's there is no European.
I mean, let's not forget Larry's point. I think it's very well taken. The cultural and linguistic barriers are so high. You're not going to sit in Helsinki and saying, you know, Portuguese law is slightly more advantageous, let's go for that. Transaction costs of getting into Portuguese law is so overwhelming, it just won't even enter your mind.
And then we start on Finnish law.
Yeah, I mean,
by the way, that's why we need more unification than you.
Oh, yeah.
Because
you do need more.
People have to read that in the statute book in their 20 languages.
Yeah.
I think 20 or 23, but I don't know how many we have now.
Sure, you need more.
I've given up to learn.
Richard.
I'm not sure you.
Katarina.
But just in addition to the problem of multi-languages, there is another challenge that we do not only look at the decisions of the ECJ, but that we also provide databases where the cases of lower instances are accessible in some, not only in English, but in more languages, because we have more and more European legislation in private international law, so we need more access to the interpretation also of lower instances in Slovenia and Poland and Portugal and whatever. And this should be coordinated. This is a very huge challenge that something must be done about this. So I'm looking towards the director of the Max Planck Institute, whether he could
I guess you're looking in
initiate
vain.
something like this, or at least, also the European Commission should consider something to be done.
Richard first.
Yes, thank you. I wanted to add, if I may, a small empirical footnote to what you were saying from the European perspective. I was looking to see whether I had the figures with me, but I don't. But something like 60% of the cases before the Commercial Court in London involve parties neither of which are English. And these are commercial contracts which contain English jurisdiction agreements and English applicable law clauses. Now that says something, I think. Whether it's a choice of English law or whether it's a choice of the English Forum, because the Commercial Court is well known as operating as an impartial and very effective way of resolving disputes, better very often than arbitration, I'm not sure, but that's not without interest. But I can't resist saying that there is a widespread fear on the part of City of London lawyers and barristers that as a result of the European conflict of laws revolution, we are losing our market share, not of course to other European capitals, but principally to New York. Now this is for two reasons, or at least there are two aspects to this. One may have gone away. There was a very profound objection to the original Rome I proposal on the basis that it would force the English courts to apply conflict of laws rules, which nobody in their right mind commercially would want. And so people would exercise their choice as free contractors to litigate in New York under New York law. And that was a really serious consideration, actually. I'm not sure it was entirely well-founded, but it was certainly a real fear.
It's also a lot cheaper right now.
Well, okay. And there is also some evidence. I mean, at the moment it's anecdotal evidence, but I simply report what I'm told by colleagues who practice law in the City of London, that the effect of at least one of the recent decisions of the European Court of Justice on the Brussels regulation, not actually Russo and Jackson, but the Eric Gasser case, has actually been to cause, if not a hemorrhaging, then certainly a sort of a dribbling away of dispute resolution and therefore applicable law application from England to the United States.
I can't believe that the U.S. is winning a competition with the U.K. in law. That's pretty impressive. But,
I think it's partly because a lot of the business we're talking about is banking business, and of course the big players.
Yeah, but I'm wondering about that because I mean you know a lot more about the specifics of this, but sort of viewing it from afar, what I was thinking is that the New York law firms are actually competing less effectively for international law business than the Charm Circle firms in the UK, and that part of what's going on in the UK is that these firms are basically reaching out to other countries, and whereas in New York, basically the whole game is New York. It's like that New Yorker cover, you know, New Yorker's view of the US. So, and that the UK approach is actually a more effective way to compete internationally than the New York firm approach. But what you're saying is, it's, you know, the New Yorkers are winning. So.
Well, no, I'm not saying it's winning. I'm saying that we are to a small degree losing our market share because of what seems.
It's a form of flight from regulation, right? I mean, like investors are fleeing the New York Stock Exchange because and they go into London. The same could be said if you conceive of that as a prohibitively or as a regulatory scheme that's not superimposed that makes life more difficult. You know, you will see defection from it by whoever can.
Of course, I should say what the English lawyers are saying by way of riposte is no, don't go to New York and litigate, simply arbitrate in London, and that's outside the Brussels regulation. They're not of course outside.
Maybe. And also the two examples you mentioned, Erin, about the credit card companies going to Delaware or Nebraska. Couldn't this be seen as examples where the law market generates a race to the bottom? Because it does benefit the one side of the industry, Other states may compete to offer even better
but,
incentives. What about the consumer?
The
Well, but I
key here
think-
is that Congress did it,
Right,
right? I mean,
exactly.
if the states
Right,
could,
but if-
could shut down that law market, several of them would, right? I mean,
Uh-huh.
I'm sure California would step in and say, no, you can't get Delaware law, you can't locate and get in Delaware
Yeah, this
law.
is a
And in the book,
federal
we actually
artifact.
use
Right,
it
but if
as
it
an
wasn't a
example of-
federal, if we had a choice of law regime that was based on the law market idea, it would encourage this kind of
Not
mobility, wouldn't it?
Well, not necessarily, because you've always got mandatory rules operating. And again, the big question in Europe is when do those mandatory rules become super mandatory rules? It's impossible, again, to have a sort of general rule on that, that works in every case. A way to do that is to have discipline. You know, the federal government steps in when the states get too out of line and too chaotic. But another way is to kind of institutionalize that and say that the federal government is going to preempt the state result whenever they get chaotic, defined as giving too much power to the courts and not enough definition at the statutory level. So that's the way I think to achieve a balance, and that's something that can be done by a federal statute, but also I think is something that to a lesser extent is evolving just because of this dynamic among the states and between the states and the federal government.
Yeah, we used to do it as a pathology about how that essential element for the mandatory override is gone, right? And so the states can't protect their citizens. But the weird thing is when you go back and you figure out why did that rule come about? It didn't come about to help credit card companies, right? That rule came about because a lot of the states had their usury laws pegged at fixed rates and at fixed interest rates, and so we ended up with this high inflationary period in the 70s, and so it was bumping up against that cap, and so borrowers were saying we can't get mortgage loans because we're up against the cap and it's prohibited in the state. So Congress, in an effort to free up money, passes this thing, but then the Supreme Court picks it up and it becomes this, huge, suddenly about something else, about credit card companies.
And just to add one little element, the usury laws were, a classic example of super mandatory rules. In other words, that overrode choice of law clauses. So the states were exerting their chaotic force here, and the federal government stepped in, and the result, was somewhat perverse. But that's the dynamic that we're talking about.
Well, one slightly hopeful anecdote about legislative lawmaking with regard to choice of law, which was, and Sim would know about this rule, but Nebraska had one of the oddest choice of law statutes ever.
Are you sure it wasn't Kansas?
No, I'm positive. We had a statute that said we will borrow a shorter out-of-state statute of limitations unless it's shorter. This thing was the source of personal embarrassment to me because about once every other year I would get a colleague who would call and say, have you ever seen this thing? So my colleague and I from UNL, we went down to the legislature and said we can no longer tolerate the humiliation of having this thing on the books in Nebraska, and they promptly repealed it at our urging. So there is some hope for rationality, I guess. But my more serious question is, and this is more to Mathias, but anybody else is welcome to comment. I guess I tend to agree with you that the law of large numbers being what it is, it's going to be hard to predict the distribution of substantive laws if you're a big firm, and so the marginal effect of choice of law is probably pretty small. But I'm wondering about the transaction costs, that are pegged to actually litigating particular cases when the result remains uncertain for no good reason. And I don't know whether anybody's ever studied whether that's.
I don't know, but I can tell you the personal experience I had. I was as a German citizen and a U.S. legal resident. I was driving the car of a friend of mine, who was an American, to Florida, and the car was actually driven by another German friend of mine. And we had an accident in Florida with a Michigan registered car, and the other driver was from Georgia, as in Russia, Georgia, former USSR, driving a car from Tennessee. And we got out of the car, and it turned out it was the fault of the local cops, as they admitted, it misrouted traffic. We got out of the car. We talked to each other, and I said to my friend, "This is a great conflicts case. This is wonderful." So I went home, I called my insurance company, and the adjuster had no idea. So I finally talked to the insurance company lawyer, and I said, "What are you going to do in this case? This is so cool." And he said, "We're just going to pay it."
Yeah, and that's just it. You all have to pay these conflicts cases. Insurance companies never pay anything without getting it back.
No, I know, but I mean, they didn't figure this out. They said, "Come on, this is ridiculous. It's got to be average, right?" And I said, "Well, you just come." He said, "Yeah, we average it out. We have a pool. Everybody throws in so much money. Everybody takes in so much money. At the end of the day, we don't worry about this."
No,
right?
that can't be right. I mean, if you look at the cases, it must be that they say which is the law that favors us least, and assume that applies. And
on the national average, the national insurer, it evens out.
But this is a cost of the system, because in the end we all pay for it. Whereas theoretically, at least with better rules, more predictability, the insurance maybe would settle it or would litigate it or whatever.
And I mean, as far as I remember, there are many American cases of insurance contracts, especially in the conflict of laws field.
Insurance is one of the fields where it's still fairly alive.
So apparently cross-border insurance is something very common.
Well, now, I mean, that's in the process of being considered. I've got a paper on that.
Although that was big business for, I mean, particularly with regard to the pollution cleanup cases, whether the dumping in dumps could be considered a sudden and accidental release. I mean, there was there were widely differing rules involving that, and a lot of money at stake. So that was one place where there was a big difference.
Now we don't get as many of those because they are redrafting their contracts to put better clauses in there. But we still get a lot of automobile insurance cases. I mean, 200 cases a year still.
Right. So they are litigating.
Yeah, because different limits on stacking and subrogation and so on.
Yeah.
But when they don't like it, there's another example where Congress stepped in with the Graves Amendment, because they had all these owner liability statutes and all these wonderful choice of law cases that furnished exam questions, and Congress steps in and passes a statute that says they don't even get rid of owner liability overall; they get rid of owner liability in the context of rental insurance.
That's right.
That's a really good example. I mean,
because of the insurance law, the insurance lobbies. So, I mean, it's just another example of where Congress gets in. And so I think, in a way, what you really are more likely to see, I think, is in these areas, not sort of arguments about choice of law, but really arguments of either harmonization or federal preemption, really stepping in areas that matter.
But it's a funny thing. I mean, several people have said in this room, chaos, it's chaotic. But everybody says, or it comes down to saying, we prefer chaos to some attempt to bring order into this.
No, I say chaos, but there is a way out of it.
Yeah.
Well,
I think what we heard this morning about your Louisiana statute and the effect that it had on trial judges, that was quite impressive.
It's doable,
But it's in one state.
It's a funny thing too about our chaos, right? Because as we were just saying, like if it's an area of law that really matters to the state, where we really sort of feel some need to, for regulatory authority, then we tend to see a congressional law that federalizes and preempts. And if we see something that really matters to the parties that doesn't matter to the state, then we tend to see mobility, right? If you want to put your assets in a trust and you're worried about the rule against perpetuities, then you go to a state that's abolished it. If you want a asset protection trust, or head to Delaware, right? And so if it matters to either the state or the party, it's almost as though there's a way around the chaos. And so it's almost like the chaos is left for the insurance companies.
Usually it's a federal. I mean, my favorite story is that I did this paper on choice of law in the law market for electronic commerce. And I actually had a student a former student who was a lobbyist for Microsoft, and I was trying to sell him on this idea, the law market for electronic commerce. And so he thought it was a great idea, and he went back to his employer, and then he came back to me and he said, Microsoft already owns the federal government. It's just easier for the federal government rather than messing with this state choice of law stuff. So.
think for the market, for the law market, it is quite essential to have choice of law rules, as you pointed out, which somehow favor this law market. If you have very divergent choice of law rules, this may not be the case, or may be the case only in some areas. If you have divergent choice of law rules, like we had in Europe before the Court of Justice intervened in the field of corporations, real seat doctrine versus incorporation doctrine, then the law market cannot function.
Well, it can function. I think what we've ultimately concluded is that the choice of law rules function at the margin. They can make it better or worse, right? So when Congress steps in with choice of law rules that knocks out element 4, you've got a problem. Or if you've got something else going on, it can create a problem. But I guess what we're discovering is that there are other institutions that play such a huge role compared to the choice of law decisions. That if you've got those other institutions operating, you can handle more chaos, and if you don't have it operating as effectively, then...
And also, and you say I focus only on tort and contract. I would not deny for a moment that the areas where uniform choice of laws are imperative, for example, with regard to real property and secure transactions. But you cannot, the market needs to rely much more on predictability and maybe family law. But we have uniformity in those areas. I mean, the conflict of laws revolution did not affect the Lex Loz, the citus rule for property. The Uniform Commercial Code has secure transactions, choice of law rules, which are virtually uniform. We don't have big problems. We have marginal problems, but no big problems in the areas where it really, really matters. I just think the uniformity claim in contract, and particularly in tort, is overrated. Not in lots of other areas. I mean, trusts and...
What about matrimonial property and
we have
succession?
we have pretty much uniform.
But it's not clear that you
One
need...
more question.
Okay.
If you don't mind a comment. Halfway through his talk, Professor Reimann mentioned that there were other salutary benefits to choice of law improvement, even if they didn't impact the market. We've heard from Professor O'Hara and Professor Ribstein about how they can marginally impact the market. I would think that the way out of the chaos, as it were, would be to look for ways to improve choice of law rules through any method that actually produced results that solved the problems abounding choice of law chaos, that provided those other salutary benefits, that were not, as Professor Simeonitis has observed, of some chauvinistic, and that at the same time those better rules would also lead to more efficient markets. So whether the chicken precedes the egg or the other way around, we could say we're going to set out to be efficient, but in the process, hopefully we would also not be chauvinistic or any of the other problems that we might observe leading to the chaos.
Well, in some cases, like you said about the prescription rule there are apparently chauvinistic rules.
Okay, yeah, I'm going to be off. I'll see you all later, but you can talk about me.
I take it unless there is dire desire still, you can actually finish 5 minutes short and leave any remaining questions to
Let's do that.
the dinner that will be coming short. Stephen will talk about the dinner in a moment. I've been thanked today about 3 million times, which of course is very inappropriate in several ways. First, because of all the work that has been done by others in this building, Stephen and Neylan especially, who've been really working incredibly hard for this. And secondly, of course, because of every one of you, because we put this conference together and actually assigning tasks to you and telling you to do certain things, and some of you did and some of you did to some extent, but really I know that this is opposing something on people. I think it has worked out actually. I think we have had a conversation in which we may like or not like what we have seen, but we have engaged actually with different approaches and different ideas and different actual solutions to choice of law problems. And maybe some of you go home more educated. I certainly go home more educated. I will bring my brain away from the oral state in which it is at the moment to an anal state tomorrow, trying to organize what I've actually learned today. But thank you, every one of you, for coming here, for making this possible, and for going through an entire day, some of you with considerable jet lag. So thank you very much for that. And Stephen Wilson.